You are now listening to Comp Corner, brought to you by the law offices of Bradford and Barthel.
What is up, everyone? Welcome to Comp Corner. I am your host, Nasir F. Adil, with the offices of Bradford and Barthel. Welcome, workers' compensation friends, adjusters, attorneys, judges, families, dogs, and really anyone. We are very happy to have you listen in. Now, here on Workers' Comp Corner, we're going to discuss workers' compensation-related topics with guests. And along the way, we're going to sprinkle in some topics related to pop culture, sports, comedy, and really whatever you, the listener, want to talk about. Speaking of, please be sure to email your comp or pod-related questions directly to compcorner@bradfordbarthel.com. Again, that's compcorner@bradfordbarthel.com. It's awesome to get your questions and updates. And whenever your question is read aloud during a Comp Corner episode, our client relations team here at Bradford and Barthel is going to send you over some swag and merchandise as a thank you for participating. A little later in the podcast, I'm going to answer a question that was recently submitted to compcorner@bradfordbarthel.com from friend of the firm and adjuster, Cheryl. Cheryl, thanks in advance, and we're going to get to your question towards the end. On today's episode, my big bro, Amir Adil, also a colleague here at Bradford and Barthel, is going to join us, and we're going to talk about the changing and evolving landscape of California workers' compensation. This got me thinking about the changes that I've seen in workers' compensation since I started at Bradford and Barthel in 2010. Then I realized, even though I started about 15 years ago, I realized there's been a ton of workers' compensation changes even in the last 5 years alone, really since COVID, March of 2020. It's funny how a lot of us look at life BC, which is now before COVID, and life AC, which is after COVID, and workers' compensation is no different. Now, we could all easily talk for hours about each and every one of these major seismic changes we've seen in workers' compensation. But since COVID alone, so over the last 5 years, some of the major transformations, in my opinion, include one, remote hearings, which have been a real game changer. Now, with the exception of trials and expedited hearings, we're pretty much a 90% or even higher remote industry. Now, in effect, March 1 or so of this year, video call system is going to be enforced by the WCAB, which is going to be the new normal. Now, it's crazy to think that it really took a worldwide pandemic for us to all go remote. But if you ask around, I think the vast majority of us prefer the remote system. Why? Well, judges don't have to have crowded in-person courtrooms. Also, attorneys don't have to drive an hour plus to get to the board. And guess what? Well, we actually, surprisingly enough, get things done even more efficiently. It's forced us to all resolve things before hearings, and it's really streamlined the whole process. Negotiations and settlements take place before hearings, which mean we all win. Speaking of in-person appearances, post-COVID, we also rarely have in-person depositions and also rarely have in-person doctor examinations. Over the last 5 years, I've taken one in-person applicant deposition. Over that time, I've taken dozens of applicant depositions and probably 10 or so doctor cross-examinations. Now, you ask, what do I miss about not taking in-person doctor depositions? The answer is not a damn thing. Now, anyone who's ever taken a doctor deposition knows that the attorneys often are squeezed into the smallest room at the doctor's office. It's almost like there was a hidden requirement that only the doctors saw, where the attorneys had to squeeze into the tiniest closet or doctor's examination room. Now, imagine you're in that tiny closet, right? It's usually before 8:30 a.m. or after 4:30 p.m., because, doctors tend to make more money in their actual practice, not having to be cross-examined by lawyers. But in that tiny little examination room, you had both attorneys, the court reporter, and of course the doctor, who had to talk law and medicine for about an hour. Nobody misses being in person for that. Now, if the attorneys like it better to not be in person for those doctor examinations, I can guarantee doctors also like it better too. There's one rule that I live by, which is happy wife, happy life. Another rule that some of us live by is happy doctor, happy workers' compensation case, just like how we all live by, right? Now, other post-COVID related changes include telemed evaluations, which are far more normal. Prior to COVID, it really was a taboo for an evaluator to only have telemedicine availability. This often led to automatic replacement panels. And in turn, this really dragged the cases on, having to wait for new panels. Now, post-COVID, it's far more acceptable and efficient to have telemedicine evaluations. Another change, post-COVID, we now see electronic service as being far more accepted, being a far more accepted means of service. Before 2020, not so much. Now, as for the law, over the last year, we've seen case law that now allows for the Labor Code Section 4060 panel process to start based on applicants or applicants' attorneys' objection letter or something triggering the start of that process. Before the last 2 years, the case law really and the statute only allowed for a delay or denial letter sent by the defendant to trigger the panel process for 4060 panels. Now, the key we've all kind of learned, and I think we're all going to really instill on Comp Corner, is if you're not evolving in workers' compensation, either in claims, either in law, either in medicine, whatever, then you're really, really getting left behind. On Comp Corner, we look forward to keeping you updated on everything so we all stay ahead of the game together. Now, we could all easily spend a whole podcast or 10 or 20 talking about all the major changes that we've seen in workers' compensation over the last 5 years, even over the last 15 years, ever since SB 899 or even SB 863. But what I really look forward to talking about are not only the changes, but really what are we all going to see in the next 5 years and beyond in workers' compensation? Where's workers' compensation going to be in 2030? Where's workers' compensation going to be in 2050? Now, before we introduce my guest, Amir Adil, I have to take a minute and make a Super Bowl 59 pick. Now, we've also already talked about changes in workers' compensation. A much wiser man than I once said, the only thing certain about life is change. Now, I agree, except when it comes to the Super Bowl. As much as it sickens me, I've come to the fact and the mental realization that the Chiefs are going to three-peat. There will be no change in the Super Bowl winner. My kids, their grandkids will see nothing but Chiefs victories, three-peats, 30-peats, who knows. And I'm a diehard Niners fan. Go Niners all the way. And the Chiefs winning yet again brings up so many fan scars, really sports PTSD. But even as petty as I want to be, and believe me, I can be very petty when it comes to sports, I have to pay respect to the Kansas City Chiefs franchise. They have the best quarterback. They have the best defensive coordinator. They have the best head coach. And that's why they are on the verge of true sporting greatness. And believe me, it sickens me every single step of the way. Now on to our guest, Mr. Amir F. Adil. All right, I am with my older brother, Amir Adil. Some would say that I am the Frank Stallone to his Sylvester Stallone. Others say I am the Seth Curry to his Steph Curry. But what I think is more proper is I'm more like the Dwight Schrute to his Michael Scott. What do you think? Is that more apropos?
I think I'm more the Mose to the group.
The Mose, good old Mose. Underrated, by the way. So obviously, you're my older brother. For those who are listening, it's just my brother and I. There are 3.5 years separating the elder Amir Adil versus the younger Nasir Adil. And for those who are and are not in the know, we have varying styles. I am the lover.
Do we, though?
My brother is the litigator. Well, let's go off this, okay? At the Oakland and San Francisco boards,
oh my gosh, I know
what was the average CA lawyer calling the two different brothers. Why don't you go ahead?
It wasn't even just a cop, man. It was some of the judges, and I'd walk in and like, oh, you're the bad brother. Good morning, Your Honor. Nice to meet you. No, you're the bad brother.
Well, here's the thing. I wouldn't say anyone really called me the good brother. I think by default, I was a good brother to your bad brother, but it doesn't mean you're a bad attorney. And comp wise, I don't think you can get anyone better than my brother. So he might be more aggressive, but in litigation, that's exactly what you need. So as far as our family goes, two brothers, both lawyers. My wife is also a lawyer. Our father, what's our father? What occupation was he at?
Used car sales?
Used car sales. So you have two lawyers, three lawyers, then you have a car salesman. So you could just say that our family was never known as far as being the most loved family, I guess you could say.
Do you remember that dinner we had, I think after you passed the bar? We went out. I remember it was me, you, and our parents, and we were at a restaurant. And I remember sitting there going to our mom, if we saw a car accident right now,
I remember that.
you would be the only witness that they'd called to the stand because you got two lawyers and a used car salesman. Who are you going to call to the stand? Only this lady's credible.
Impeachment galore, right? So one of the stories our mom talks about was when we were kids. Gosh, I must have been like maybe 6. My brother was probably 9 years old. As you can imagine, being the younger brother to an older brother, I was getting
we were
beat
older,
up.
Man. No, we were older.
All right. Let's not embarrass ourselves on the podcast. Okay, fine. We might have been more.
I don't want to misrepresent. Probably like 16 and 19, but
no, there was no teenagers involved. Let's go for the median age. I was probably 8. My brother was 11. Anyhow, my mom would hate it when we fought. Because back then my mom would be on the phone. Back then there were no cell phones, kids. This is life pre cell phone, pre technology. There was a thing called a landline. Okay, so on the landline, your mom and dad used to be on the call, and they'd be basically tied onto the landline. So my mom would hate it when she hears her two sons fighting in the background. So my brother and I, we agreed to fight in silence. So my brother and I'm getting my hair pulled. He's probably beating the crap out of me. I'm just trying my best to try and keep up. My mom looks over and she's on the phone and she sees her two sons just fighting in silence, just going at it. Hair pulled one way, wedgies going the other way. And my mom just is on the phone and she starts laughing. She's like, you guys are so funny. You guys actually came to an agreement to get into a fight. Why don't you guys just come to an agreement not to fight? That would seemingly better, right?
That was not in the option set. It was just not an option. I mean, it makes sense now. When you hear it as an adult, it makes perfect sense, but it wasn't an option at the time.
Yeah, the 80s were a different time altogether. So one thing I wanted to kind of talk about as far as the podcast goes, I think we're living in a post-COVID world, obviously. Believe it or not, the calendar is now saying 2025, so there's a 2025 going on. And for those of us who practice, there's been a considerable change post-COVID versus pre-COVID. Would you agree with that assessment that says, life in the workers' comp world and practicing world is drastically different in 2025 than it was 5 years ago this time?
Oh, 100%. It's substantially different, and I think for most people in a good way.
What do you mean by good way?
The practice has gotten faster, more streamlined. It's easier in the sense that there's less wasted downtime and there's less wasted time. All of the times you got up and it's 5:30 in the morning and you got to drive to San Francisco or drive to a board that's still quote local for you, but because traffic and because of commute you have to leave before your kids are up, and then you're fighting traffic already by 5:30 in the morning and you're barely getting in 2-3 hours later to your quote local board, only to find that everyone else is late.
Sure.
And no one's worked on the 5-pager you sent them 2 weeks ago or 2 months ago. All of that wasted time is gone because now judges call in by 8:28 in the morning, 8:38 if somehow they're late a little bit. And they want dispositions and they want to know exactly what's going on. They're not late as much either, and you need to be on time. The other side needs to be on time.
Sure. I think the irony of ironies, I mean, it took us, obviously, the pandemic was horrible. I think that's an understatement of the year, but it really took us a pandemic for us to realize in the workers' compensation community throughout the state that, you know what, we don't need to be at the board for 95% of hearings. And the irony of ironies, we're all more productive. That's the productive part. I mean, before your average 8:30 hearing, okay, you wake up at 6:30, you get on BART or drive, you get to the board at 8:20, 8:30, 8:35. Everyone else would kind of roll on in at 8:45, 9 o'clock. You talk, your disposition be done around 9:40. You get that one piece of paper, taking it off calendar. You walk into a crowded room where the windows are fogged up because there's so many people in there. You got walkthroughs ahead of you. You probably get out of there with the judge at 11:15. By the time you're back in the office, it's a good 11:30, 12 o'clock.
But I will say I was in favor of doing more remote work
Mm-hmm.
on a day-to-day basis and remote hearings before COVID, because
Mm-hmm.
the very few times I appeared in family court or something like that outside of the WCAB realm, you had
Yeah.
people who would call in. They would do court calls. They would do remote appearances. Even on the criminal docket, they would do arraignments with people
Yeah.
who did not get brought in from county or wherever they were locked up to the criminal court. And if you can handle a criminal proceeding where you're going to potentially deprive someone
Mm-hmm.
of liberty or potentially even life remote, you telling me we can't adjudicate the UR
Right.
determination?
Exactly. Can't figure out 5 business days from a service of a UR. Right.
we
Exactly.
can't we can't do a court calendar counting remotely from one another. We all need to be in the same room counting on our fingers out loud.
You know, I think not only is it more productive, but it's really more settlement oriented, right? Like I never did PDF settlements prior to March of 2020 because I didn't have to. I'd always have the handwriting from chicken scratch, and I'd always handwrite it out, and I'd get my settlements done. But now, sheesh, the amount of settlements we do before the 8:30 hearing is just skyrocketed. So you don't have to be at the board till 11:30. Granted, there are times you have your MSCs that go for 2, 3, 4 hours, and that's going to happen every now and then, of course. But all things considered, I think the California has wisely considered and changed a lot of the appearance rules. And obviously for trials, we're still going in person. And I think March 1 is going to be the new law. Is that correct? We're going to be on video call. What do you think about that?
Yeah, we'll all be looking at each other 5 years older than we were before.
5 years older, hopefully not 50 pounds, but that's the new reality though. So talking about kind of post-COVID, we're looking at as far as new attorneys go, right? No, not even new attorneys, but in your opinion, what's the drawback, the positives about practicing at home versus the old school practice of, hey, 5 days a week, we're in the office with a hard file? What are some of the realities of the new change that we're dealing with?
I think if you know what you're doing and you know how to practice, then remote is perfectly fine for all of the time, if not next to all of the time.
Yeah.
You don't need to brainstorm with your colleagues or bounce things off of coworkers, then you're fine. But if you're new,
Mhm.
that's different, right? You're brand new. You
Yeah.
need to be in an office if you're going to practice in an area like where we practice. Look, lawyers have been known historically to practice alone, right?
Hmm.
The law practice is full of a bunch of solo practitioners.
Sure.
So, do people need to work with each other? No, of course not. But workers' comp is a pretty specialized area of the law. It's gotten a lot more technical, it's gotten a lot more in depth than it was a few decades ago when we were starting. And if you want to learn it quickly and competently, and you have the opportunity to work in a firm, learn with coworkers, then I don't think there's a reason to hide in your home. In other words, put affirmatively, stated positively, go to the office, learn from your coworkers, ask questions, learn,
Yeah.
read, find out what's a good way of doing things, because you don't know. Why reinvent the wheel?
Yeah. Yeah.
If you want to be
It,
a solo, then go work as a solo.
Sure. I think it's funny because even though life is way more productive, like I said, working remotely, there really isn't anything, in my opinion, that could replace the unbelievable amount of experience that you get by just knocking on the attorneys down the hallway and saying, "Hey, can I pick your brain?" I mean, we could do that over the phone, and we do. Obviously, I call you plenty of times during the day to pick your brain. But man, when there's 3, 4, 5 attorneys, you could just get together and just roundtable something. That's such an invaluable experience that the newer attorneys. I mean, I feel bad for them because they don't have the same interaction that we had back in the day. What do you think about that?
They have that option though here, right?
Yeah,
I think just about every new hire that I can think of, I cannot think of an exception, but every new hire we've had whom I can think of who's new to either A, the practice of law, or B, specifically to workers' comp, they come in a lot or are regularly just in the office.
Sure.
Or if they need to be remote because, life is bonkers and everyone's experience varies, then the managing attorney and or senior partners or mentors are on the phone with them incessantly. You know who I'm talking about. Other partners we deal with, they're like, man, I just spent 2 hours on the phone with this person. I've spent 15, 20 hours on the phone with this person this week. Well, before COVID, it would be the same 15, 20 hours, except it might be in the office going through the files together in person.
Right. Oh yeah, that's from an employer standpoint. I think that's where there has to be flexibility, right? Because other industries, in finance, tech, I think we've looked around and what we've seen on TV. Whenever there's an employer who says, "Hey, you need to be back in the office X amount of days per week, or else," the reality of that is that no one wants to be forced to go back in the office, right? And one thing I think that it's been kind of cool at our firm is that we've been able to maneuver around that and say, look, it could be either or. It doesn't have to be one way, right? And by doing that, you have attorneys who do work out of state, right? Who can work out of state, out of jurisdiction. And remember before, I mean, pre-COVID, none of us had files outside of our personal jurisdiction because you didn't want to drive to San Diego or Santa Ana or Eureka, right? But now you get on the phone, you can cover Reading at 1:30. Hey, let me call in at 1:35. Let me cover, Tarzana. But yeah, the flexibility it's nice having that for sure. I think you can also get talent to work with you, talent to work for you. I think it's a real win-win across the board. What do you think?
Absolutely. I think the flexibility is welcome. Like I was saying, I was in favor of it before COVID. I obviously didn't see the pandemic coming. Otherwise, I would have made a lot of money investing in some stuff. But I think the flexibility is welcome in our area of the law. And I think in a weird way, our clients were actually ahead of the curve by decades. A lot of the insurance companies had gone remote and had employees working and learning our area of the law, and vice versa. People in this jurisdiction learning other jurisdictions many years ago.
Did you know Bradford and Barthel has free monthly workers' compensation webinars that provide CE and MCLE credits? Topics have included soup to nuts, such as calculating TD and PD, applying the AMA guides, defense tips for drafting CNRs and STIPs, taking effective doctor depositions, and many more. Register to attend a live event, or you can review over 100 accredited hours of recorded webinars on our training page at bradfordbarthel.com.
Now, thank you very much to friend of the firm, Cheryl, for submitting a question to Comp Corner. Her question is, I have a case where EDD paid benefits for 1 year when a case was denied. The injury later became accepted and TD benefits were picked up. Cheryl's question is whether she can automatically take credit for the 1 year EDD paid. Great question, Cheryl. The answer is you can take credit for EDD's payment period as soon as you actually pay EDD back. It's not enough to simply say that, hey, EDD paid state disability for 1 year, so the carrier can automatically take credit for that 1 year and there's no more exposure for TD benefits. You really have to go back and pay EDD. Once you actually pay EDD, and that's the pro tip, then you're golden. Then and only then are you able to assert that SDI period as credit towards the statutory cap. Thank you very much, Cheryl, for your question. And why don't you tell our listeners, how many years of workers' comp experience do you have?
Oh gosh, what is today? January 2025. I think I started with B&B January 2003. So I
Whew.
got my 22nd anniversary coming up I believe I started with B&B the day after MLK
Wow.
2003.
Okay. So one thing I asked some of our guests are, I started comp here January 2010. There was a thing called a cell phone, believe it or not, that existed at that time. But back in your day, when you first started,
hmm
2003,
hmm
you were pre cell phone. So
No,
how
we had
did you
cell phones.
communicate?
Cell phones
All right.
existed.
All right. Let me
But
take a step back. Go ahead.
so
How did you contact your adjusters back in 2003?
that's
Go
what I was going to
ahead.
say. So
Okay.
when I had to go up to Ukiah, for example, I had a Nokia brick.
Nice.
I
Zach
think the
Morris. Zach Morris, Saved by the Bell, everyone. If for
no,
those who
no,
know, you
that
know.
was the old thing. I had the cooler, sleeker ones. I was in style, man.
Of
But it
course.
had no coverage up there because you're in Ukiah,
And
right?
there's probably still no coverage. Sorry, Ukiah.
So, and I think back then, the WCAB remote office was in the multi-purpose room of the Episcopalian Church.
Nice.
I always wondered about the separation of church and state when I was there. It's always interesting when I was parking in the church to go to WCAB. But you would have to go to I think it was the DMV in the parking lot across
Hmm.
that had the old payphones. Remember those nasty phones?
Oh, sticky.
Yeah. So
Sticky, sticky, sticky.
if I had to call a client that had a 1-800 number, I was okay. If not, then I think I had to use the back of my credit card. Remember your
Oh
credit card
yeah.
was also a calling card?
Oh yeah. Oh yeah. Oh yeah.
So you use or you'd have some change in your pocket to call claims, 1-800-claims.com and get
I
your
th-
authority.
I think for those of us who are lucky to have kids, we also experience the wrath of getting age shamed and technology shamed. My daughters are 14 and 11. My nieces are a little bit older than mine, but all I'm trying to say is that when we try to explain to them technology and how things used to be back in the early 2000s or even the 90s and 80s, they look at us like we're absolute dinosaurs. I think some of those stories about using calling payphones to call your adjusters, I think those come across the same way. Um, what's your best piece of advice for a new attorney? I know you've started over 20 years ago, but if a new attorney, what's some of your advice that you'd give to a newly practicing comp attorney?
The thing I tell our newer attorneys now is the same thing that I did myself and have found in the years between. Read as much as you can, man. Just
Mm,
just open up a file, try to figure out what the issue is, talk to your
right.
managing attorney, your managing partner, your mentor, whomever, ask them what the issue is. And once you figure that out, go pick up a
Mm,
treatise, right?
mm,
Go to treatise.com, whatever one you follow, pick up a treatise in the old law library if you got one. Go to your payservice.com. I don't want to give anyone any free advertisements here, but just research the area. So
yeah.
if it's a TD issue, go to the TD chapter, try to find this exact subdivision, the sub issue you're working on, but spend time reading the whole thing, and then work
Mm,
the next file. Do the same thing. Find issue spot. Go back to the treatise. Go back to the authority. Pick up the labor code. Read, do it again on the third, and then you know what? A couple of months later, several months later, you're going to know what you're talking about.
yeah. No, that's solid advice. I think the funny part of workers' comp, I mean, for those non-attorney colleagues that we have, for those who are in claims, of course, you all know what I'm talking about. The attorneys on the line, you all know what I'm talking about. But for those non-attorneys that we talk to in our lives, they're like, "Oh, how was workers' comp in law school? Tell us how you did." And you're like, "We didn't take workers' comp in law school. I mean, they might have offered it as an elective, but come on, none of us took it." Then they're like, "Oh, but you learned it for the bar, right?" And you're like, no, it's not on the bar. Maybe have like one like sample question that the Cal bar threw out afterwards. But to your point, none of us learned this stuff prior to practicing. So the more you're able to just read up, ask, continue to read, that's how you gather knowledge. And that's really how you just become just more accustomed to the law, right?
So, in my mind, I think the way I try to understand the start of the practice of law is it should be treated similarly to how the medical professionals do it correctly, do it rigorously, by
Hmm.
which I mean after medical school, before you actually start practicing on your own, they go through a residency program, right?
Yeah.
So the medical school graduate is now actually learning how to practice medicine in hospital with patients, but also with residents or other people, other doctors, physicians, training them on what to do. So if you treat the start of law in a
Yeah.
similar manner, where you know you got the degree, you know you got the license, but you don't know what you're doing.
Right.
So
Right. Right.
treat
Right.
that with respect,
Right. Right.
go about it in an informed manner. You'll probably be okay. I do know, and I remember these people in law school. I'm sure you had a similar experience. There are law school students and there are young lawyers who just think they know everything and they run into problems real quick.
Oh yeah. Oh yeah. It's called workers' compensation, not insurance carrier compensation, as you taught me a few years back. Now, as the firm's large loss lead, can you just tell us what that entails?
So I handle a lot of the cat loss claims that come in or the catastrophic injuries. And the definition of catastrophic injuries kind of varies from person to person, practitioner to practitioner, but generically speaking, it means a serious, severe loss that the employee or a person has suffered.
Hmm.
A serious, grievous injury, a catastrophic loss for the carrier, and of course, a catastrophic loss suffered by the individual, right? A death claim
Sure.
can be a cat loss, for example. Another way historically that I would define it before a few decades ago was the reverberating claims, the claims that
Hmm.
wouldn't settle because the laws were more loosey goosey a few years ago, a few decades ago. So your person who would suffer a ankle injury at Cheap Mart USA, and that ankle injury, which should have just been an ankle injury, a few
Right.
months later turned into a knee injury, and then turned into a compensable hip, and then the
Oh
hip
yeah.
wasn't solved, so they were getting their back fused, their lumbar spine fused, and
Skin
that
and its contents. Right.
yeah, and then the cervical spine was hurting, and then the shoulder, and then 7 8 years later they were doing carpal tunnel releases on a lady originally had an ankle sprain.
Sure.
That became a cat loss because it was just an unending loss.
Right. Right.
Oh yeah.
So, one thing, the theme kind of we've been discussing throughout the last couple months and years is how the industry is busy. Obviously, the average claims examiner may have had, gosh, probably like 100 files 15, 20 years ago. They probably were upwards of 150 to, maybe 220 now, right? And similarly across the board, I mean, AAs may have more files than they used to have, defense attorneys as well. But with the industry being busier, ironically, I think it's better. Now, would you agree with the assessment of the industry is busy yet better?
I actually thought I was one of the only people who thought that. So
Mm.
I'm interested to learn that you think so. I think the industry has gotten a lot more efficient
Hmm.
in the last couple of decades. I've been participating in it. I think
Why is
that
that?
I have an unsexy answer, an unappetizing answer. I think, frankly, from my vantage point, across the political spectrum, both sides of the aisle, both major parties, names of whom I barely want to say because I'm not a fan of either, um, both sides decided that the labor code needed to be changed because the way that the decisions were coming out were not
Yeah,
in their favor. So, one governor of one party in April of 2004 substantially changed almost unilaterally. I don't think this governor wrote it himself. I'd be shocked if he wrote it himself, but his party shoved SB 899 down the
hmm,
legislature's throat, and that substantially rewrote the law, added huge limitations on TD, rewrote how we arrive at PD, right? AMA guides welcome
sure.
work restrictions of this, that, and the other gone, apportionment rewritten.
Yeah.
The WCAB didn't believe it, so then Escobedo was needed a year later to say no. It says what it says. About that time, VR was divorced from the WCAB, from the labor code, really.
Right.
Medical care came under serious constraints, and then with 863, medical care, in a weird way, the way I look at it, was taken away from the WCAB. Hey,
Mm-hmm.
we're not even going to have this in your jurisdiction anymore. It now goes to
Right.
IMR, to the AD is assigning a different vendor to take care of it. Can you
Sure.
imagine how much the legislature and the
Oh yeah.
administration trusted the labor code's interpretation to the WCAB if they took away one or two or three or four areas of the law?
That spoke volumes. It really did.
So in those changes, which were tough, and I remember a lot of people who are opposing counsel saying how SB 899 was unconstitutional, and they were taking out the kitty bag and circulating it around to hire appellate firms to attack it. I remember SB 863 was just a grotesque violation of the attorney-client or the doctor-patient relationship.
Yeah.
But through all of it, medical care's gotten better, man.
Ironically enough, that should really be the theme of this podcast, is the irony of ironies, right? We've probably mentioned that phrase like 6-7 times, but
You know how,
who thought that would be the consequence of it? Who thought that would be the end result or one of the
you know who didn't
subsequent
think
results?
you know who didn't think that would be the end result? A lot
Ooh.
of injured worker advocates and the judges who said adding evidence-based
Yeah,
medicine,
yeah,
adding
yeah,
peer review, requiring medical literature to endorse doctor prescriptions were a good idea. I heard with my own ears, saw with my
yeah.
own eyes, was in the hearing rooms when the judges were saying this is unconstitutional, and you're going, evidence is bad. All right,
That's a new way of looking at law,
medical
right?
guidelines is bad. All right.
So you've been kind enough to share your time, but one thing I wanted to ask all our guests towards the end of their experience here was, where do you think California workers' compensation will be in 50 years? So let's fast forward 50 years. Let's get our George Jetson time machine or DeLorean to the future with Doc Scott and Marty McFly. The year's 2075. We're here in California. How general or broad or specific do you think California workers' comp will be at that time?
I think it'll get, unfortunately, a lot tighter than it is. I think we might have already seen the heyday of
Hmm.
benefits just being doled out,
Yeah.
because I remember a very popular opposing counsel whose name I don't want to use was famous for saying that if I sign a claim form, my signature alone is worth $2,500 on a CNR.
Sheesh.
Right? This is decades ago. This is a long time ago. This is a long time ago.
He probably thinks a few more zeros should be added to that now, huh?
Yeah, inflation.
Yeah.
But I think that as the international dynamics and politics have changed, I'm not sure that um, it's going to be more rewarding to injured workers. But I do think that they're going to be, I hope anyway, fingers crossed,
Yeah.
they're traded fairly, because in a good way, TD rates have increased, right?
Yeah. Yeah.
So
Yeah.
right, you got a 2-year cap, yes, and that might seem tight, but most people recover from most injuries in 2 years, and if they don't, there are exceptions.
Sure.
Is it perfect? No. I didn't write the law. I didn't write the law. It is what it is.
Or Eddie
Permanent,
Murphy Raw.
yeah. Permanent disability. I wish I would have wrote Eddie Murphy Raw. Can you imagine?
It
Permanent
doesn't
disability.
it doesn't date
Got-
itself well. It's gotten anyhow. Go ahead.
Yeah, you just got political real quick, didn't you?
Whew.
But PD rates have gone up, right? They're not
Yeah,
paid
yeah.
at whatever $70 a week, 140 a week, now 290 a week.
Right.
Is that enough? No. Is it what you really would want to be paid if you truly had a permanent disability?
Yeah.
No. But it is better than what it was. Is VR back? No. Was it always treated as a secondary cash cow? Yeah. So is a
Yeah.
voucher valuable? I mean, it's better than nothing. Is it what people deserve who truly need to be retrained? I made it through college with 2 degrees and I want to say a minor or 2 or 3 for less than the $16,000 VR cap.
Isn't that crazy?
For much less than
Yeah.
the $16,000 VR. So was that waste money good? I don't think that was a good idea. That was waste. Medical care has gotten better. So do I think medical care will continue to get better? Yeah. If you actually have good medicine, good doctors,
Sure.
good protocols. Yeah. If you have bad doctors, bad medicine, then it'll get worse.
Sure. That's another thing about comp that those who are too extreme on one side don't quite understand that it's a benefit delivery system. We all know that. But when you start taking injured workers' rights away, then no one wins. Defendants don't win. Why? Because then you're going to have much more savvy AAs and applicants who are not going to be happy with what they get, right? But when you have fair systems with fair TD amounts, fair TD rates, then you have fair amounts of years getting paid. It's a win-win system like that. No one's getting undercut. More cases settle. Quality of healthcare improves. Quality of wage replacement improves. And no one loses across the board. So I think a healthy way to look at things is exactly that. I mean, having it be fair across the board. So right now we're going to do a little Spitfire 5 and 5. Okay, let's see what you got for us, older brother. First question. Paper or plastic?
Plastic.
Easy answer. You know, those people nowadays, they won't go paper. I know there's a little guilt associated with taking plastic because, you know, it's not as good for the environment. But if you're walking up a flight of stairs or if you're carrying groceries from the car to the garage, how are you going to tell me with a straight face that plastic isn't better than paper? It's an easy call.
You can reuse plastic. They're good little waste bin liners.
All right. So now let's go for the second one. Ready for it?
Down.
I know your answer, but let's get it away. Ready? PQMEs or AMEs? Go.
Oh my gosh. I can't even spell the other one. Only PQME. The amount of times I've wanted to violently vomit because I hear those words. AME quality. Ugh. The amount of cases I've had to sub in or take over because of an AME quality job chosen by prior counsel.
Now, here's the truth, everyone. For PQMEs, I go to PQMEs 98% of the time. I'm not your attorney who's going to go to AME very often, but I'll go to an AME every now and then, right? If I got a bad panel or a specialty chiropractic, which could be problematic, I'll go to an AME. But my brother is known throughout the industry and the firm for how often do you ever, when was the last time you went to an AME?
Probably pre-COVID. I think in the last 10, 15 years, I've gone twice to an AME since 2010, 2013. And both times were basically the client ordered me, said, I agreed to this doctor. This is the only doctor we're going to use. And if that's what the client wants, that's what the client wants. But I just am still haunted by the amount of claims and cases I had to take over because the examiner or prior firm agreed to an AME, and then I subbed in, and no matter how good the objective evidence, the medical evidence, the surveillance evidence, the whatever I showed, your quote, AME quality doctor, they did better arguments than CA ever could envision.
I think AME had more power at the board than God does. I think AME is just given the God-like standard.
Well, it's an excuse, right? Hey, you agreed to this, so why do I have to adjudicate anything? You already agreed to this, doctor, so now I'm out. I don't want to play judge.
All right, now let's go to something a little bit more. How about Dave Chappelle or Chris Rock?
No. Go.
Two goats. They're 1A and 1B. I got to agree. Chris Rock he's an all-timer, but Dave Chappelle, there's something about him that's just, you just got to realize that guy just knows everything, and he freestyle. I mean, he doesn't have a bit. He just gets on stage and the guy can just freestyle and he's good to go, right?
Just talk, you listen, you laugh, and you learn.
All right. A little less controversial, but still very important for the listeners. Backstreet Boys or NSYNC?
I actually don't know either.
Oh, come on. Tell me why. Tell me why. Yeah, gotta be kidding me. Now, summer of '98, it was a beautiful time, man.
Hey,
we got it. Bye, bye, bye. All right, moving on. Let's go to number 5. All right. This is something that you're going to be a little bit more in tune with, I can tell. Ready?
Yeah.
Rambo or Rocky? Go.
Ooh, Rocky always speaks to your soul. Rambo gets you excited, but Rocky is that multi-layered kind of revelation. You watch it, you learn more every time, and you learn more about yourself every time.
That's true. For those who might know, my brother and I, we were immigrant kids, but in the 80s, there was a lot of testosterone in Fremont in our house that we grew up in. Most of it revolved around Sylvester Stallone movies, Over the Top, Rocky, Rambo. Sheesh, you name it with Sly, we were watching it. Rockies 1, 2, 3, 4, 5, et cetera, et cetera. So good answer on that one. Now, for the last one, this is a little bonus since you did so well on 1 through 5. Mount Rushmore of candy bars. Snickers will always be the number one. I'm going to challenge anyone who comes on this podcast, including you, older brother, to convince me that Snickers is not the number one seed. Please give me your other three on the Mount Rushmore. Go.
Payday bar. Payday is good.
That'll be the Abe Lincoln. That's our Abe Lincoln.
$100,000.
All right, that's our third. What else do we got?
I would say $100,000 over Payday.
Okay, give me one more. That's 3.
Ooh, that's a lot of obesity and diabetes. Let's see, number 3.
It's all pre-existing. It's okay.
It's all pre-existing. I just need anything over 0%, and you guys are paying.
Aggravation, exacerbation. Go ahead.
Yeah, and you know how many depots I've taken on the difference between those two? And the cross X's.
Oh, yeah.
Third good.
Come on. It's right there. What's wrong with you, older brother? Come on.
Man, I'm failing at the...
Have you never heard of Twix, Reese's Pieces, Kit Kat?
Solid Kit Kat, yeah. Twix, all of those are great. I probably have eaten all of those lots of times.
All right, and that's your segment.
Candy bars great again.
making candy bars and obesity great again. Brought to you by Bradford and Barthel.
Who needs
better for business?
1 when you can get diabetes 2.
Better. Like Chris Rock said, why do they call it diabetes? It should be called winnabetes, right? I mean, if you call it winnabetes, the whole outlook changes. I'm just saying, man. There's a lot of sense that comes.
If you think about it, yeah. If you can get diabetes 2 in older life, you've won. You made it number 1 to get it. Number 2, that means you got enough food in your belly to have a belly.
That's first world problems galore right there. All right. So that's enough for 5 and 5. Thank you for your honesty and your candor, and most importantly, your good advice. A big thank you to Big Bro Amir Adil for joining us today. Another big thank you to you all for listening to today's episode of Comp Corner. Do not forget to email your questions and concerns to compcorner@bradfordbarthel.com. Be sure to check us out at bradfordbarthel.com for more information regarding ratings, webinars, and legal blogs galore. Please be sure to like, subscribe, and check us out on Spotify, Apple, or wherever you frequent your podcasts. Have a great day, everyone. See you next time on Comp Corner.